Morning, Cal.
Yeah, good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and along with Robert Stickney and David Pollock, I represent Bill and Lisa Rolland. I'd like to reserve 2 minutes, please.
Sure.
The purpose of Section 76879 and Rule 1442 is to encourage settlement with good faith offers.
Counsel, can you please just address what's going on with 16-2793, which I believe is the merits case?
Right, that's still in briefing. The panelists have filed their initial brief. We haven't yet filed our answer brief. I've reviewed it. My assessment is that I think we're going to win that appeal.
Can you decide this fee issue yet until you've won the appeal?
I think you will have to decide this fee issue whether or not, no matter how the court rules.
But how is that? Let's just.
Because it would be remanded, and our assessment is we would win a trial again.
You're having your assumption is that it could either go 3 different ways, I guess, potentially. It can be affirmed completely for purposes of the appeal and the cross appeal. It could be affirmed for purposes of the appeal or reversed for purposes of cross appeal, which would mean that that would go back to punitive damages, and I assume then your client would do another joint proposal for settlement. Or it can be reversed.
We wouldn't do another. We would stay with the same one, and you have to determine.
That's your choice, but
Okay.
I'm just saying that would go back. Or it could be reversed in total, and it would go back. So the question is how is this even really, for purposes of this panel's determination, ready or right for us to determine the issue, because it could.
Well, you have to determine whether it's enforceable or not, and which essentially would be an order saying that on the apportionment issue.
But why would we do that? Because if it goes back to, if it gets reversed and it goes back, then
how would we appeal the attorney fee issue at that point?
Everything would be reversed.
Right, but we would win at the trial. We would win at the trial again. We would get the same verdict, or perhaps even better, and we'd still have this attorney fee question. So that needs to be resolved now, no matter how the main judgment
You're
goes.
asking us for an advisory opinion.
It's not advisory. It would be saying, trial court, you got this wrong, and pending the resolution of the
So
retrial.
what you're saying is it would just be a matter of doing the math depending on what happens.
Right. We're reversing you, and the entitlement to attorney fees is contingent upon math or the arithmetic.
So is this right, though, since
Yes.
there's no math to be done yet?
Well, there is math to be done because we have the judgment in place, and then we're going to have a ruling in the main
But
judgment
it's not
appeal.
final, right? Your judgment is not final.
Right. It is a final judgment. It's up on the final judgment appeal. It's just not been affirmed yet. Right.
Okay.
So, I mean, if you wanted to, you could sit around and wait until the main judgment appeal is ruled on. But my point is, no matter what happens to the main judgment appeal, the attorney fee issue needs to be decided, and it needs to be decided now. Now, it could be.
But this is the concern I have. Let's assume, for purposes of argument, that it gets reversed, the whole thing, and it gets sent back. And you have another trial judge. It may not go back to the same trial judge, because that trial judge may no longer be in that division. The new trial judge has the trial, I believe it was a long trial, this trial, and let's say it includes punitive damages, it'll be even a longer trial. Then that trial judge would have the ability to reconsider the motion for attorney's fees and costs.
A second time.
A second time, because everything would be unwound. So,
Okay.
so the question I have is, it seems to me that we're putting the cart before the horse in terms of making any determination until the plenary appeal, the merits appeal is determined, because we don't know what the resolution of that is yet.
I disagree. I think you need to decide it now. I don't think it's much different from an appellate attorney fee order that says we're granting your appellate attorney fees contingent on something happening in the trial court. And so your opinion here would be saying, trial court, your legal analysis was incorrect. We're saying these are enforceable proposals for settlement contingent on the arithmetic being determined. And you could do the same thing by just waiting for the main judgment appeal and seeing how that turns out, because it's possible that would be affirmed, in which case, the issue's squarely presented. So you can sit tight, wait for that to be resolved, or issue a ruling, but I think it is squarely presented for your decision today. So the purpose is to encourage good faith settlement offers. And here, ISMG is trying to avoid a sanction for unreasonably rejecting these good faith offers by arguing that they're unapportioned and ambiguous. And that's incorrect for three reasons. There's three reasons why these proposals for settlement are apportioned and clear and not ambiguous. And the original sin that led the trial court astray, we need to unwind, is that ISMG conflates two different inquiries. They conflate the inquiry about what is a joint offer with the question, who are the offerees? And they then assert that, well, because it's a joint offer, Mr. Acuna is an offeree. And that's incorrect. That doesn't arise from Audifred. The joint offer only triggers the apportionment requirement. It doesn't turn people into an offeree. And we know this simply by reading the proposals for settlement. And if you look at specifically paragraphs 2, 3, and 5 of both proposals for settlement, it makes clear that the party making the offer is either Bill or Lisa Rolland. The party to whom the offer is made is ISMG only. And then most importantly in paragraph 5, it says that the amount is to be paid by defendant ISMG. And because Mr. Acuna then is not an offeree, he doesn't have the ability to accept, and he's not exposed to any sanction for rejecting an offer that he never received.
It's still an all or nothing settlement with which all the claims will be resolved against both of them.
Right.
I think there is case law that says that you can condition joint proposals, you can condition proposals for settlement on releasing claims of all of the defendants.
Contingent on another offeree accepting?
Another person accepting.
No, it's actually
an employee.
Right, it's actually, I'm misunderstanding your question.
There are cases that stand for the proposition that you can send a proposal for settlement to an employer, let's say, for example, and that the proposal can be conditioned, so it doesn't have to be to the employee, but the claim, if the employer accepts it, is sufficient and extend a valid proposal for settlement if the employee, you release the employee as well.
Yeah, that's our view of the situation. There's a proposal that goes to the corporate defendant, and then there's an additional condition that says, well, by the way, we're also going to release your employee from the litigation. That was a very important part of these proposals.
Was Mr. Cunha sued individually?
Yes.
And then there was there a claim, I can't remember, I'm asking just wrong, was there a claim for any type of, you're the employee, therefore the employer is vicariously liable?
There was both vicarious liability.
He was also sued individually.
And Acuna sued individually, and then ISMG sued both individually for its own negligent hiring and then also for vicarious liability.
Okay.
But the actions are all all the actions stem based on the employee's action, what they did.
No, because there's the employee's action which triggers the vicarious liability for ISMG, and then ISMG also hired him and trained him, and then the claim is, well, ISMG didn't do that, and you are independently liable, and that's part of the discussion about Rule 1.
So the allegations weren't that they were solely vicariously liable for Mr. Cunha was sued individually.
Yeah, we don't.
As well as a corporation individually and vicariously.
Yeah, we both sides agree that that's the situation. So the proposal establishes that Mr. Acuna is not an offeree. There was no consideration asked from him. He didn't have the opportunity to accept. He didn't have the requirement to sign the release. It's only a deal between ISMG and
Well, if ISMG accepted, then he would be released.
he would be released,
The
right?
employee would be released as well.
Due to no action on his part. He had no control over ISMG's decision. And so our view is that Mr. Acuna really has no place in this appeal here. It's really just a dispute between us and ISMG from whom we're seeking fees. And then the second problem...
And then the issue also is then for purposes of apportionment, because Judge Warner at the Fourth said, which was interesting because I hadn't thought about this before, which is that the purpose of apportionment is to allow the trial court to determine, quote, whether the judgment against only one of the parties was at least 25% more or less in the offer, depending on which party made the offer. And so the question is, here was the proposal that was made, was it the verdict you recovered, I believe, was still 25% more than...
Way more than 25% more. It's more than 100% more. We got a verdict of $4.132 million against basically all of it. That's Bill Rolland's verdict against all the defendants, and then Mrs. Rolland got a verdict of $500,000, which is more than the $300,000 offer she made. There's no question these are extremely good faith offers. We wanted to settle this case. And right now we're having this litigation because they're trying to dodge the sanction that should follow from unreasonably rejecting a good faith proposal for settlement.
Council, we've taken you a little bit over, but you have a couple minutes for.
Okay, I appreciate that.
Just like
Thank
to
you.
rest on your brief, rest of your brief.
Do you want me to sit down here? Saying?
I'm saying your time is up. Would you
Okay.
like to rest?
Yeah, well, I wanted to make the other, just, if I can just have 20 seconds.
I'll give you 20 seconds,
Okay.
but we'll take it off your 2 minutes for rebuttal.
Okay, great.
So you have a minute, 40
so we're
seconds
saying
for
it's
rebuttal.
different from audit because it's 100% to 0%. And the key part is that our proposal for settlement says to be paid by defendant ISMG, and the auditor proposal did not say paid to whom. That's the difference. And then we say that we win under Harris Specialty Chemicals for the reasons stated under.
Thank you, Council. Good morning.
Good morning. May I please report? My name is Christina Plato, and I represent the Applebee's International Security Management Group, well referred to as ISMG, and Georgia Kuna.
Can you address the first issue that we addressed with Mr. Burns?
As to rightness,
Yes.
yes.
I'm not sure it's rightness, but it's something similar to that.
Yes. So if the main appeal is ultimately the judgment reversed, we will have to start all over and do everything over again, have another hearing on entitlement. So we do agree and we do believe that it will be reversed, that all these issues will come up again. So the decision here may not resolve all of that.
So therefore, is this an advisory opinion?
Yes, we do believe that. Now, this appeal, as you heard, involves the trial court's denial of Rolland's motion for entitlement to
Well,
attorney.
okay, so if we're going to talk about the merits, then why is this not I know it's being discussed as a joint proposal for settlement, but why is it not just a single proposal for settlement that has a condition on it for a settlement of a claim of an employee?
Well, the Florida Supreme Court in Autfred v. Arnold is abundantly clear, and I'll quote from the case. When a single offeror submits a settlement proposal to a single offeree, and the offer resolves pending claims by or against additional parties who are neither offerors nor offerees, it constitutes a joint proposal subject to the apportionment requirement. And that's
Your-
exactly the
Your
situation
argument
here.
is that there's no apportionment on the face of the proposal for settlement.
That is correct. So while the proposal states on the line, parties to whom the proposal is made list solely ISMG, it also purports to resolve all the claims against Acuna. Additionally, there's a mutual general release that was attached to the proposal.
But why exactly, I'm not sure that offered stands for that proposition, but it specifically says, it does apportion. It says $2 million for purposes of ISMG to be resolved, right? And then it also says, what was the other one for the wife was it $2 million?
No, 300,000.
It would be
300,000. 300,000. If the release is purely for ISMG and the employee Acuna is an agent and an employee of ISMG, and the claim will be released, what is there for him to consider?
Well, there are multiple things.
He's out of the case if ISMG pays.
That is correct. But the release that is attached to the proposal for settlement, which is a non-monetary term and condition of the proposal, states that the settlement amount will be paid by ISMG. And then it goes on to define ISMG as the company and George Acuna. So on that basis alone, it's unclear who's actually paying that settlement amount. And as we know, if there's a discrepancy, an ambiguous discrepancy between what is listed in the proposal, what is listed in an attached release, that creates an ambiguity, a fatal ambiguity to the proposal. For example, in Stasio v. McManaway, 2006 DCA case, there was a proposal for settlement that there was a slight discrepancy on the amount of the proposal. While it was listed as $60,000 in the proposal, and the number of $60,000 was listed in the release, there was also one portion where $59,000 was spelled out. While it appeared that the parties had intended for the proposal to state 60,000, this discrepancy between the proposal and the attached release created an ambiguity. And that's precisely what we have here. We have a proposal that states it will be paid by ISMG, and then we have an attached release that states it will be paid by ISMG, but ISMG is defined to include a CUNA. So based on that, it's unclear who is being paid. Additionally, the purpose of the apportionment requirement is to allow the parties to know the value of the claims against each party, and allow each party to independently evaluate and settle his or her respective claims.
Well, again, the joint proposal, I mean, you're calling it a joint proposal, but I think it's just a proposal for settlement, specifically said, any and all claims would be released if ISMG accepted the proposal for settlement. And, I mean, the Florida Supreme Court, in the case of Allstate Indemnity versus Hinkson, specifically said that the purpose of apportionment is to allow the trial court to determine, quote, whether the judgment against only one of the parties was at least 25% more or less than the offer, depending on which party made the offer. And in fact, you know, all or nothing proposals are still acceptable. It's a question of if you have an all or nothing proposal and you don't accept it, and the claim, the verdict for any of the claimants is not 25% or higher, then no one gets the fees. But all or nothing proposals are allowed.
That is correct. All or nothing proposals are allowed, but all or nothing proposals are from the position of the plaintiff. Joint proposal on the offering plaintiff side, saying here's X amount that we're demanding from you, and this is what happened in the Hinkson case. This is X amount that we're demanding from you, and if you accept this demand, then all the claims against that all the plaintiffs have brought against you will be released.
Are they not the plaintiffs?
They are, but it's two offerees rather than two offerors. So in the Hinkson case, the court found, well, there's only one settlement amount that is being demanded of the defendant. The defendant knows the exact amount that's being demanded from it specifically. In our case, we don't know what amount is being demanded from ISMG and what is being demanded from.
Because of the wording, your argument is because of the wording in the release, or the wording that says ISMG, which includes all the officers, directors, employees, et cetera, am I correct? So therefore, Mr. Acuna, the argument is, doesn't know what proportion, if any, he's going to have to pay.
That is correct.
So therefore, according to case law also, the minds of the people that have to do this settlement, it has to be clear to them what's going on, and there can't be any ambiguity. The court has to clear up.
That is correct.
Okay, I got you.
Yes, and the Hinkson case specifically turned on the fact that there was one offer being made to one offering. And that's not what we have here. And this case is also very similar to the second DCA, Miley v. Nash, where in that case, the proposal stated the amount that would be paid by Kyle Miley, and that in exchange, Mark Nash, the plaintiff, would dismiss both Kyle Miley and Glenn Miley from the case. The court found in that case that it was a joint proposal, and that proposal was unapportioned. Ultimately, apportionment wasn't necessary because it fell under the narrow exception of all the claims against Glenn Miley were based solely on vicarious liability. But that's not what we have here. When these proposals were served, the operative complaint was the original complaint. There was a list of allegations or claims against all parties, and then there was a separate negligent security claim against ISMG. So that's why that exception doesn't apply, because it's not based solely on vicarious or derivative liability.
Counsel, in conclusion.
In conclusion, we request that the court affirm the denial of the Rolland's request for entitlement and attorney's fees based on the fact that these are unapportioned joint proposals pursuant to Oxford v. Arnold and subsequent Miley v. Nash.
Thank you very much.
Thank you very much.
Counsel, you have a minute and 40 seconds.
Not 39?
How's it, yeah, 40?
40.
Not 40 more?
Okay.
Okay.
That's fine.
Let me just ask you, this is for my application, and I won't take this off your minute and 40 seconds. Tell me again, just so I'm clear, your argument on why we should go ahead and make a determination on merits at this time.
I think the issue is going to arise no matter what. Like even if we lose the main judgment appeal, we're going to go back to trial.
What if when you go back to trial, you settle?
Then I think it's not different from an appellate attorney fees order that says we're granting you contingent based on if you prevail ultimately at trial. I think that's commonly done in appellate attorney fee orders, and that's essentially what we're asking you to do with this appeal. Otherwise, if you don't, what I think you should do.
But in those instances, though, there is a trial that's going to be had by virtue of the appellate order. Here, you have an appeal pending in this court on the merits.
Right, so what I think you should do is sit tight, wait to see how the main judgment appeal works out. If we win that appeal, then you should definitely decide this. If we don't win that appeal, then you can consider the rightness issue. But I think it's still right at that point, because otherwise it's just going to be, rebriefed after, some additional trial. So that seems to be wasteful to me.
Let me ask you a question though, because let's assume, and I don't know because I don't know anything about the underlying case, but let's assume that your cross appeal, you prevail on the cross appeal and you are entitled to punitive damages. I assume that when the original proposal for settlement was submitted, that was not on the table. But if you have punitive damages on the table, would you not do a new proposal for settlement?
That would be a call by the trial lawyers. I'm not sure if we would do a new one at that point in time. But just to be clear, their appeal of the verdict is not something that would completely eliminate the verdict or end the litigation. It would just send the case back to the trial court.
No, I understand that, but obviously the punitive damages would add additional damages.
They could,
So,
but right now we're already, more than double or almost double on both of the proposals. So the math works out. I want to point out two key points. One is that we're still struggling with who the offerees are. There is no question. ISMG is the only offeree. Whether Mr. Acuna is confused or not, it just has no place in this appeal. He is not. He has no opportunity to accept. And so the only question is this clear enough? Not perfectly clear, but clear enough for ISMG to understand what it needs to do to settle its claim? And the answer, I think, under the case law, including audit for it, is yes. And then
and it was an all or nothing proposal, which
right, which just happens to have a general release, which is just so extremely common in litigation that it doesn't deserve any discussion. And the second point is when they're talking about apportionment, they're mixing up this idea of claims and
actually,
damages.
there is no requirement under the rule that you have to submit a release with a proposal for settlement.
Yes, but it's extremely common.
No,
And the reason we did it was not.
I understand that, but I'm saying that it causes sometimes more problems.
Right, but we weren't trying to play gotcha and get them with fees. We wanted to settle this case. So we tried to give them the best, most reasonable offer we could, which includes the release of their employee. But this point about the claims and damages, which is it that you're trying to apportion, it's the damages to be paid by the party, not the claim. So like when ISMG has decided, well, how much of this is for Acuna and how much is it for me? It's all for you. And then there's just an additional condition that your employee will also get released. So there's no question ISMG knows I got to pay $2 million to make this case go away. Court doesn't have to get involved to clear out any confusion. I interrupted. What was going to be a question?
No, it's not a question.
Okay, all right. So we're asking you to sit tight, wait for the final judgment appeal to get worked out, and then when we hopefully win that appeal, decide this case and reverse the order, remand for determination of entitlement or the amount of fees.
Thank you very much.
Thank you.
Thank you both.
All rise.
Very good job. Thank you.